Welcome to Missouri Law Matters, a podcast all about your Missouri court system. I am your host, Matt Hamner. I am a judge on the Missouri Court of Appeals for the Southern District based in Springfield, Missouri. Thank you for being here today. And if you're enjoying this podcast, if you've enjoyed the other episodes that we put out, don't forget to like and subscribe to our podcast on all your various platforms of choice, Apple, Spotify, wherever you might find us. If you want audio and video, don't forget to check us out on YouTube and subscribe to us there, as well as leave a comment. Let us know how we're doing, things you like, things you don't like, things that you think we can improve, or if there's anything that you think we should cover on a future episode. Also, finally, don't forget that both the Missouri courts and the Supreme Court of Missouri have new Facebook and Instagram pages. Don't forget to go follow them there and comment and interact on the content that's being posted there. It's great information about the court system and the wonderful people that do all of the work within it. Joining me today is my friend, producer of this podcast, Michelle Broxton, my partner in crime in this project. And she is here today to help me out with a concept that we have guided around as what is more commonly known as a mailbag. In the process of doing this podcast and the episodes that we've put out and the issues that we've created, we have been asked various questions on social media, through research that's been done, or people just passing us on the street and asking questions. And so we thought it would be a great opportunity to have producer Michelle as a representative of the people to ask me, a judge, all those questions that are burning that you may want to know the answers to. So we're going to do a little bit of a mailbag today. Now, before we get started with that mailbag, I do need to caveat, and I warned producer Michelle I was going to do this. I do have to give a little bit of a caveat. Judges in Missouri are bound by certain ethical rules. We don't play by the same rules as everybody else because of the positions that we hold, because of the decisions that we have to make, and because of the need for us to remain impartial while making those decisions. We're not allowed to talk about just anything. We're not allowed to comment about cases that are pending, and we're not allowed to comment on specific issues that might end up in front of us. So when folks come up to me in a grocery store and they say, "Hey, Judge, why did the court do this in my case?" I probably can't answer that question. And if you have specific questions about, well, why is the Supreme Court doing this, or why is this case going to trial, or this thing happening, or that thing happening, in specific cases, I can't ever answer those questions. And it's frustrating. It's frustrating for me as a judge that, I certainly have opinions about things, but I can't share them. It's frustrating for members of the public and people that I interact with because they're like, "Well, you're a judge. Shouldn't you know these things?" And I'm like, "Well, yeah, but I just can't talk about it." But understanding all of that going forward, I still think that we can have a healthy conversation about questions that you all may have about the court process, judges, and the legal system and how it works. And we're going to do our best to provide answers to those questions. And producer Michelle has put together some questions for me to respond to. I have not seen these questions in advance, so I'm very excited and very nervous all at the same time. This could be my last day as a judge, folks. It's entirely possible.
No.
So, producer Michelle, thank you so much for being here today.
You're welcome.
All right.
I will say I'm much more comfortable on that side of the camera.
I imagine so. Well, that's the beauty of this format. Just pretend that's not even there.
Okay.
It's not even there. You and I are now just having a conversation. Okay. After I'm done talking to the internet, now I'm here to talk to you. I'm very excited about the questions that you have gone through. Is there anything else that we need to cover before we get started?
Well, one of the things I noticed when you were talking is that you said one of the things that's different about judges in Missouri is you guys can't talk about these things. Just so y'all know, I'm not an attorney. Is that true for all states or just for Missouri? Could a judge in, Illinois talk about cases?
It varies.
Okay.
It varies state by state, and federal judges have their own set of rules.
Okay.
Missouri, we have our own set of rules that governs it. They're the Missouri Judicial canons. And those canons are the rules that we have to operate by. And in Missouri, it's tricky because we have different types of judges at all sorts of different levels. The majority of the judges in our state are elected. If you're not a judge in St. Louis or Kansas City or Springfield, and there may be one other one, maybe Boone County that I'm forgetting, but if you're not in one of 4 or 5 certain jurisdictions in the state, all of your judges are elected. And so they have to run, and they have to campaign, and they have to be able to talk to people about who they are and what they do. So our judicial canons have rules that allow for that. And so in addition to the judicial canons that we have about not being able to talk about pending cases, about not being able to discuss issues that might come before us that we may have to decide, we also have specific rules about campaigning and things that we can and cannot do while we campaign. we're not like other candidates. Like if you run for state rep or governor, you can make I'm going to do this. I'm going to raise your taxes. I'm going to cut your taxes. I'm going to raise your taxes. Well, hey, who knows? Maybe somebody's got a good idea. I don't know. But, they make all sorts of promises about this is what I'm going to do. This way. As judges, we can't do that. I can't walk in and say, hey, this is how I'm going to rule in these types of cases, because then I can't be a judge on those types of cases, because I have prejudged. I have already formed an opinion about the types of issues that I'm going to see or the things that may come up in front of me. So I can't then be a judge on cases like that. So that's why it's really tricky in Missouri, because we have a mix of elected judges and judges that are chosen under the nonpartisan court plan. Other states are purely elected. Other states are purely appointed. Every state is a little bit different. Most states are a mix. They're like Missouri in that they're a hybrid of the two. And so because of that, they have all developed their own ethical rules as to what judges can and can't say. Certainly I know what the rules are in Missouri. As far as what other rules apply in Delaware or Virginia or something like that, I don't know the answer to that question. I would assume that there is something similar.
So one of the things that I have learned since starting to work for the courts is, and correct me if I'm wrong for this, but a ton of research and thought and deliberation goes into a ruling behind the scenes and into a case behind the scenes. And then once a judge makes their decision and that comes out in writing, something that I've just kind of learned to say for myself is that decision stands for itself. And that past that point, it isn't discussed by the court. Do you find that to be pretty accurate?
Yes and no.
Okay.
In that when a court makes a decision, and it depends, and this
Unless
is
it's
at all,
appealed or
yeah,
something.
and this is at all levels of the court. We have trial courts that handle, those are the courts that most people think about when they think of a court, where you go and there's jurors or there's witnesses and you have testimony and lawyers object and do all the stuff. All the things you see on TV, that's your circuit court, that's your local county court or your local city court or whatever. Those are those courts. Then you have appellate courts. You have a court of appeals and you have a Supreme Court above that. That process is a little bit different. They don't have a trial. They don't hear witnesses and do all those things. They review everything that happened at the court below, and they make their decision based on the record, the written record of what happened at those courts below. Now, once a trial court issues a decision, there are various motions that can be filed to ask the court to reconsider that or to consider other things or to do various things with it. So when a court issues a final decision, it isn't necessarily the last word if there are other things that can be addressed. Now, in a trial court, there's usually a period of about 60 to 90 days after a judgment is entered. The trial court makes its judgment where you can file motions and you can address issues with that judgment. But once that time period expires, whenever that is, that judgment then becomes what we would call, quote, final judgment. And then at that point, your only recourse is to then ask the Court of Appeals to do something different with it. So yes, there is a point at which a judgment that is issued by a court, be that a trial court or a Court of Appeals, becomes final. And there's no further discussion about that particular judgment unless you have the right to appeal it to another court.
In any decision, maybe half of the people agree with it, half people don't agree with it. And so sometimes the news media may choose a headline that's going to sell papers, and there's a lot of discussion about it, but there isn't like a trope of people that go onto the news media and say, well, this is what we really meant, and this is how we made the decision. It's just sort of, the decision stands for itself. That's what I mean.
All right. I understand.
Okay.
I was thinking more of a party line as far as you're actually thinking about members of the public. What happens if they want somebody
they want to walk
to
up to you and say,
to them?
yeah, like, why did you say that? Why did you do that? That's what I mean is that I think, the court is always saying, the decision is the decision. And it's usually pretty well outlined in the decision, like what the laws were used and things like that. And so I don't know. We can move on. I don't want to belabor that. But I do think that's something that comes up a lot is basically, why won't you defend yourself? Why won't you say anything? And I think people don't understand that a judge's decision is not it's not a PR move. It's based on the law. And that, if people don't like the way the law is written, that's really a conversation to be had with the legislature, or it's really to be had with someone else.
You're absolutely right. When judges issue opinions, there's a reason why we issue written opinions. Right. The appellate courts, the Supreme Court, we issue written opinions that explain all of the reasoning. And that is the voice. Because oftentimes when a court of appeals or a Supreme Court is speaking, it's not just one person speaking. There are multiple judges. There are multiple people who are signing off on this is the decision of the court as a whole. This is our collective agreed to decision or opinion on a particular issue. So it wouldn't be appropriate for me as one person voting on that decision to say what it is that the court felt or what the court said. What the court said that everyone agreed on is in that written opinion. It's in that written decision. And that's why I think courts have always been hesitant to send out people to talk about decisions that are made, because there's always also the element of an issue that you see one time, you may see that issue again in another year, or you may see a case just like this in a couple of years. And you have to be careful about what you go out and talk about, because you don't want to prejudge the next issue that you may see that may come up. But I think it's always been a tradition, and a well-rooted tradition, that when courts write an opinion, they write a decision, they take the time to put all of their reasoning and rationale. That is the decision of the court. That is the court speaking. And that's the only way that the court as a whole speaks about a particular issue or about a particular case. You know, I as an individual judge may have my own opinions and have my own thoughts about things. And it's not unusual for judges, 5 years or 10 years after a case is over and it's long been passed and it's been in the history books. It's not unusual at that point for judges to maybe talk about cases that they've heard, experiences that they've had. But usually in that short-term period that you're talking about, when all the press is getting written and people are like, well, somebody needs to come out and explain this, that's probably not going to happen, because the courts speak through their written opinion. And that opinion is out there. It's for everyone to read. And I would encourage everyone not to base their opinion as to what a court does only on a headline, or on 2 lines that they see at the top of a Facebook post, or in a tweet, or an X post, whatever they're called now. I don't know, but don't base your decisions based on that. If you are really passionate about something, if you really have questions about a decision that a court has made or what they have done, take the time to actually seek out the written decision. Read that decision and see if it doesn't answer some of the questions that you might have. I have a feeling that in a lot of cases it will.
Okay, so let's start with a myth. What's something that people think happens in court but rarely happens?
Something that people think happens in court that rarely happens. I would probably say drama.
Really?
Yeah. Because, and a lot of this has to do with TVs and movies, which we've talked about. People come to court a lot of times and they expect it to be really entertaining. They expect there to be a good guy and a bad guy, and they expect there to be this aha moment where an attorney has a witness on the stand and gets the witness to admit that they were wrong the whole time, and everyone yells, "Gotcha!" And it's just this great experience. I think that anyone who has actually come to a court in Missouri and been part of a legal case will tell you that for the most part, that is not true. That coming to court in Missouri is not nearly that entertaining. There's not always this big drama and this gotcha moment. Most of the time, it's just your friends and neighbors who have disputes. They have things that they can't agree on, or have issues that they need to resolve, or maybe a marriage to dissolve. And they're just trying to get their problem sorted out. It isn't dramatic. It isn't crazy. It's not always loud. It can sometimes be loud, but it isn't always loud or exciting. And I think that's what people, I think, are really surprised about when they come and they sit through a docket, that it isn't Jerry Springer all the time. It isn't Judge Judy or the People's Court all the time. It's more laid back than that. It's more processing and dealing with people's, problems. And so I think once people get over that understanding that you're not going to come in and it's not going to be this big, huge aha gotcha moment, I think it's more approachable. It's more of a grasp to them. And I think it's a little less intimidating.
When we think about those moments in the movies or in TV where this really eloquent, strategic trial attorney, you can just watch them like like a cat with a mouse, take the unsuspecting witness to a place, and then they get them there. To me, when I think about the skill that it takes to pace like that and know how to ask those questions, I notice that they will have a legal pad, and they're often mapping out almost like a decision tree on a legal pad. And they're working their way through that often the night before, or like a couple of nights before. And then every night after the trial, they're sort of reworking that based on what's happened that day. What is that process? And when do people learn that? Did they learn it from their grandparents who were attorneys? Did you learn that in school? Do you learn it from your internship when you're at, your first practice?
I think you pick it up in a couple of different ways. I mean, it just depends on kind of what your background is, your training. I had no other lawyers in my family, so I didn't learn it from anybody else. I had to learn it as the process as I went along. Some people, it's just the way they have to organize their thought. Being a trial attorney and being the attorney that's cross-examining witnesses, it's art. It's as much art as, painting a picture or writing a song. And there are so many ways to do it, and every attorney does it differently. And so whatever you see on the legal pad or however they have to map it out, that's just how they create their art and how they've been trained to do it. That's why every attorney kind of does it differently. You have to do it the way that fits your particular style. One of the questions that I had gotten was specifically about elected judges. We talked about some of the judges in our state are elected. I used to be an elected judge, and I guess I should clarify. Even the judges in the state who are part of the nonpartisan court plan, they are up for election. They sit for what are called retention elections. Rather than running every 4 years or every 6 years, like associate judges and circuit judges, you will see them on the retention ballot within a couple of years after they're appointed. And that is basically just, do you want to keep this judge or not keep this judge? And you vote yes or no. And provided they get a majority of that vote, they are retained. And those terms are for 12 years. And so once you get by a retention election, you don't show up on the ballot again for 12 years. And then in 12 years, the public has the option again to either keep or not keep a particular appellate judge. So just to clarify, all of the judges in the state of Missouri do sit for election. Just some of them sit more often and have opponents in contested elections.
One of the things I've noticed is that a lot of times people don't realize they need to turn their ballot over.
Yes.
There's a lot of stuff on the back of the ballot that people, I think, sometimes they don't realize.
I think that absolutely does happen. So, always check your ballot. Always turn it over and make sure there's not other stuff on the backside that you need to be voting for.
There's a lot of local stuff.
Hopefully you have good election judges who are pointing that out to people as they come in. Hey, double check, make sure, but always check both sides of your ballot because a lot of times there's a lot of stuff. As far as elected judges and those judges that sit for contested elections who may have to run against opponents in local elections, one of the questions that was asked was, how do elected judges who have to face voters on a more frequent basis, how do we balance that, the desire, the need to be retained to continue doing this job that we love so much, with having to make a decision that we know isn't going to be popular, with having to make a decision and run into a problem that we feel people may not be as excited about, that a decision that may be correct as the way the law is written, as the way that we are required to follow it. But do we ever give any consideration or thought to, and how do we balance making decisions of that type that we may know are going to be unpopular, but we know are the right decision based on the law? I think the answer to that question, to the extent I can answer it, at the end of the day, our job as judges, and we take an oath to uphold the law. Our job at the end of the day is to follow the law. And I think if people really read the opinions that get issued and read those decisions that are made, they will see that the issues are based solely on the law, on what the law is and how that law reads and how that law is interpreted. It isn't based on what we think the law ought to be or what we think the law should be. It's based on what the law is. Because as courts, it's not our job to change the law. Our job as courts is to interpret the law that is passed by the legislature, that's adopted by the people through initiative process. Whatever the law is, be it the Constitution, be it the statutes, we interpret what is there and we can't change it. Now, looping back to the question, which is, what thought do you give? How do you balance that? I don't, because when I make a decision, I don't give any thought to whether it's going to be popular. I don't give any thought to whether or not it's going to cost me a job or it's going to cost me votes in a retention election or another, because I took an oath that said I wasn't going to do that I wasn't going to make decisions based on what other people thought, that I was going to make decisions based on what I believe the law says and what I'm required to do as a judge. I frankly have had to make numerous decisions over the course of my legal career that I didn't agree with, that I didn't want to make, but that's the way the law was written. I do, of course, give thought to the impact of what impact it's going to have on the people in the cases and the people in front of me. But I don't really give a lot of thought to whether or not it's going to be popular. Because at the end of the day, my job is to follow the law.
One question I have just as a normal, everyday Missourian is if the law doesn't change and a judge's decision is just to apply the law, then what is the need for appellate courts?
The reason that appellate courts are so important is that even if you have a decision in a case that has come before that interprets the law in a particular way, every case is different. You know, there is almost never a case where the circumstances of something occurring is exactly the same in one case versus the next. And so the appellate courts are there to review, to make sure that the law was properly applied in the particular case in front of it. So those little details can matter. Those little details can make a difference in whether or not, even though there's a case out there that says this thing is what this law means, another case can come along with different circumstances that could change whether or not that law even applies in the particular case. And so that's the role of the appellate courts, is to make sure that when those cases come up through our system, to look at the little things in the cases that make them different from the cases that came before and decide whether or not it changes.
That's really helpful. So it's the details in the case that could even determine whether or not that law even applied or whether
Correct.
the law was applied correctly.
That is correct.
Thank you. That helps me. I have two questions. You can pick which one you want to answer first. Is there a mentor or a defining moment early in your career that still impacts how you serve? And then my second question is, heard of a walk-on song?
Walk-up song, yes.
Walk-up song?
Like
Okay.
for a batter in a baseball
Yeah.
game or something
Whenever
like
you
that,
need to kind of get yourself into a good space, do you have an internal walk-up song?
Very good question.
Answer them in the order you prefer.
I will answer the mentor question first,
Okay.
because that'll give me time to vamp to think of a good walk-up.
Okay.
I have been blessed in my legal career in particular with several mentors that really shaped the way I understood how to be a lawyer and how to be a judge and how to practice law. The first mentor I probably really had was Judge Ray Price, who was a Supreme Court justice in Missouri. He was Chief Justice the year I worked for him, but he gave me an opportunity to be a law clerk right out of law school. It's my very first big person job. I was very excited. And I got to spend a year working with Judge Price and seeing how he handled cases and how he thought about cases. I got to see a lot of examples of different kinds of lawyering, good lawyering and a lot of bad lawyering. And I'll tell you, I learned more probably from looking at the bad lawyering than I did from looking at the good. But over that time and in that experience, Judge Price really taught me about the way to think about the law, and particularly the way to think about the law in the role that a judge should have in that process. You know, because everybody has a part to play in the system, the lawyers, the litigants, and the judges themselves. And it's important that judges understand the role that they play in that process. And he was instrumental in teaching that to me. And so certainly as a judge, I would consider him to be one of my biggest mentors. Really was the first person that really kind of walked me into that process and got me to think about this life. As far as a walk-up song, that is a more difficult question for me because I am a lover of all music. I'll be listening to something one day and then 2 days later I'm off of that and I'm on to something else. But if it was really going to be a walk-up song, if I really needed to get some energy and really kind of push it forward, I would probably go with Gloria by Laura Branigan, which was a fabulous song that came out in the early 80s. And was co-opted by the St. Louis Blues, my favorite hockey team, for their Stanley Cup run that they made in 2019, I think that was. I've always loved that song. I always thought it had a great bop to it and a great energy to it. And that'd be a great walk-up song because I also like a walk-up song that kind of makes people go, what? And so I think it'd be a great reaction from people to hear me coming up to that song as well. So.
Fantastic. I'm thinking about that song now. When you think about the things that you learned from your mentor, and now you sort of live by those guidelines as a judge. When you look back to your time early in law school and then early in your career as an attorney, because you think about that person just entering law school right now or this fall could potentially one day become a judge. And so it's kind of a long on-ramp to becoming a judge one day. And so what are some of those tenets of faith or tenets of integrity that you would say would serve them well to just go ahead and start getting in these habits of thinking or these habits of understanding and believing about the law and about the legal profession that will serve them, whether they become a judge or not, their whole career.
What I would encourage folks to do is that if you have any inclination that you're thinking about becoming a judge, or that may be something that you want to do in your career path at some point, you do have to be a lawyer. So if you want to be a judge, you got to go to law school, and you got to put in that effort and go through that process and put in that time to do that. But outside of that, once you have a law degree, that's really the only qualification you have to be a judge. To be an elected judge, basically have to meet the minimum age, and you have to have a law degree. If it's something that you're considering about doing, really focus on and think about um, how to analyze the law, how to analyze issues that come up in the law. Because, there's lots of different ways to argue about, was the light red? Was the sky blue? But really think about how to pull issues apart, particularly when you're dealing with, when you have statutes or rules or things that apply to the situation. You have to kind of know how to pull those things apart and look at those issues and make those determinations. So if you're in law school and you're thinking about becoming a judge, really focus on the legal research and writing part of it, because you're going to do a lot of that as a judge. You're going to have to research, you're going to have to write, you're going to have to explain your thoughts and put them on paper so that people understand them. At the same time, sometimes as a law student, you get buried under old cases and old precedent and things that are written in a different language, it seems like, because they're so old and they're so hard to read. But understand the foundations of where the principles that we operate under in the law come from. And then the last thing that I would say to you is the day that you will really become a great lawyer, the day that you'll become a good judge, is the day that you realize that after, 3 years of law school and maybe 6 or 7 years in private practice and all the work and the experience you have, the day that you realize that you don't know anything about the law is the day you'll become a good lawyer and you'll become a good judge, because the law is always changing. You never know the law because it is always different every day, and you have to continue. And which is why in law school, they teach you how to think about the law. They don't teach you all of the law because they know it's going to change. What they teach you is a way to keep up with the law, to understand the law, so that when it does change, you can understand those changes and understand how to apply that. It is a very rewarding feeling. I truly, a couple of years out of practice, when I realized, I really don't know everything that I know about the law. I don't feel like I know it. That was, I think, when I really started to become a good lawyer, because I lost I can't think of another word to say for it, the arrogance that I know this is how it works, and replaced it with the understanding of, okay, I think I know how this works, but let's confirm that that's the way it is. And then when you start digging in and figure out, maybe it isn't exactly how you remember it or how you think it is or how you think it should be, because that's often what happens with the law is you think it should be a particular way. But when you actually look and read the law and pull apart the cases and pull apart the statutes, that's not actually the way it is. And you have to be open to that being the right answer.
What would a person do if they happened to hire an attorney who hadn't had that aha moment yet? Or maybe they're appointed an attorney who hadn't had that aha moment yet, and they felt like things just weren't going well in the case. And it was more than, I just want to make sure I win. It's like things aren't going well here, whether it's a GAL or a court appointed attorney in some other facet. What are people's options when they feel like, I just don't feel like this person is approaching this in the right way or doing this to the best of their ability?
And that's a really, really complicated question that has different answers based on the various roles that you just discussed. The rules for GALs, the rules for court-appointed attorneys, the rules for private attorney that you have hired with money out of your own pocket. They're all different. All of those various scenarios change the outcome of how it is. And I don't want to get too much into details with respect to that, because your relationship with your attorney is between you and that attorney. The courts very rarely intervene in those relationships, particularly with court-appointed attorneys. I have to tell people all the time, you have the right to a court-appointed attorney. You don't have the right to choose that court-appointed attorney. And so, your court-appointed attorney will be assigned for you. You usually don't get a chance to decide on that. But what I will tell you is that if you have concerns about a particular an attorney that's working for you, either a private attorney you've hired or a GAL that's been appointed, GALs which don't work for you, by the way. I would have parents that would come in and say, oh, my GAL, he works for me, he's terrible. GAL doesn't work for parents. He doesn't work for the parties in the case. GALs are usually appointed by the court to represent the child, and they represent children is generally what GALs or persons that are incapacitated and don't have the ability to represent themselves. But what I would tell you is if you have concerns about an attorney, don't be afraid to speak up. That's the one thing that I see is that people don't verbalize concerns that they have. Verbalize them first to your attorney. If you have concerns about things that your attorney is doing and that you have questions about that, talk to them. Don't be afraid to talk to them about concerns or issues that they have. They do work for you. They have an obligation to talk to you about those things and do those things. In rare instances where your communication with your attorney can't resolve those disputes, you can go to the courts. But what I would tell you is, again, don't be afraid to speak up if you have concerns about things that are going on with your relationship with your attorney or the attorney's representation. Because the last thing you want is to get 2 years down the road, your case is over or it's up on appeal and something's going on. And then 2 years later, you're saying, well, wait a minute, my attorney was terrible. They were doing all these things wrong. If you haven't raised that issue up to that point, then it makes it that much harder for people to understand that, well, if you were having all these issues, why did you say something?
Thank you for that. So when you say talk to your attorney first, and then if that doesn't work, raise the issue. Forgive me for not knowing this.
Sure.
Who do you raise the issue to?
You would raise the issue with the court.
But who is the court? Do you go to the clerk's office?
You would go.
Do you write a letter to the judge?
Mm-hmm.
Who do you? I mean, I don't know.
No,
I'm just a normal person. Like, who do you talk to?
That's an absolutely fair question. Don't write a letter to the judge.
Okay.
That would not be my suggestion.
I'm going to tell the teacher.
And I will tell you, in most cases, you could write that letter, but the judges aren't going to read it because judges are not allowed to communicate with the parties. So if you have an issue and you have a concern, at the next scheduled hearing, whenever you're going to be in court again, presumably you're going to be in front of the judge again with that attorney. Don't be afraid while you're in court dealing with your case to just say, hey, Judge, I have an issue that I'd like to address. And just raise your hand and just say, hey, can we talk about this? Can we address this? And make sure your attorney knows, because in this scenario, you've already talked to your attorney about this issue. You've communicated these concerns to the attorney. Make sure they know in advance that you're going to do that you want to ask this question, that you want to at least get some input and get some guidance. If everybody is on the same page about it, they can at least then be civil about it and they can communicate about it. You may not get the answer you want. The attorney may not do the things that you think they need to do, or they may not give you the answer that you want, but don't be afraid to raise the issue if you think something's wrong.
Thank you. And then if it's, like you said, a GAL isn't an adult's attorney typically, unless they're incapacitated. The person is typically a child's attorney. Mm-hmm. But a 2-month-old child can't speak for themselves. And so there typically is an adult or two who are in court with that child. So if one of them has a concern, same basic process, they would speak with the GAO first and raise any concerns that they may have. And then if that doesn't work, the next time everyone is in court, if they are an interested party to the case, they could stand in court and say, I have a concern.
Again, these questions are probably a little more complicated than we're making them because there's so many different scenarios in which these issues arise. So in my head, and there are many circumstances, probate court and other cases where GALs would get appointed, but just in, GALs primarily get appointed in dissolution cases or cases involving child custody. And they also get appointed in juvenile cases where abuse and neglect has been alleged against parents. And those are two completely different scenarios. In a private case, in a custody case, a dissolution case, that GAL is being appointed by the court to represent the child. Most of the time, the parents in those cases will have attorneys, not always, but they will have their own attorneys. That would be the first place you would go, is you would talk to your attorney about concerns that you have with the guardian ad litem. And then it would be incumbent on the attorney to then talk to the guardian ad litem, and they would then have conversations about addressing any issues that have come up. And then if if talking to the attorney doesn't resolve the issue, if working through it with the GAL doesn't resolve the issue, then it could be then elevated to the judge. Same thing on the juvenile side. On the juvenile side, parents are appointed attorneys if they can't afford one. So everybody generally in juvenile court will have an attorney. Same process. Start with the attorney, then the attorneys can work with the GAL to try to address those issues, and then further up the chain. One thing I will say about guardian ad litems have a very difficult job in our system because they are normally appointed. They are normally appointed representatives of children and incapacitated persons in various cases. They get selected to be put in the middle of a war between two different sides in the most emotional and highly volatile cases that we deal with. Family law cases, juvenile cases that can blossom into termination of parental rights cases even. So the highest pressure, the highest stress cases that we have are those types of cases. And we appoint folks to stand in the middle between two sides that aren't getting along or are very emotional, usually very emotional. Anyone would be when you're dealing with issues involving your children. And we put them in the middle and tell them, do a good job. And the process requires them to make determinations. And they generally will make recommendations to the court as to things that they think are going to be the best and what they believe based on their observations and understanding. When a guardian ad litem walks into the courtroom to give that recommendation, they know that 50% of the people in the room are going to hate them as soon as they make that recommendation, and 50% of the people in the room are going to love them. And the decisions that GALs make, they take oaths, they undergo training. The Supreme Court recently amended the rules involving guardian ad litems about 10 or so years ago to increase the amount of training that they're required to have, to increase the amount of visitations they have to have with their clients, and to do all of these things to make sure that the guardian ad litems in the state of Missouri are meeting a certain level of performance. But even with all of that being said, no matter how good of a job they do, no matter how much work they do, they are going to make a decision that at the end of the day is going to make someone upset. And it is hard sometimes, and it's hard particularly for trial judges, for appellate courts, to separate out, anger that is directed at the decision that was made or anger that is directed at something that actually went wrong in the process. We can't do anything about the anger over decisions that are made because the process requires them to make those decisions, to make those recommendations. Ultimately, at the end of the day, the guardian ad litem shoulders a lot of blame in the case that honestly falls on the judge. Because at the end of the day, the judge makes the ultimate decision. The guardian ad litem recommends, the judge decides what the ultimate decision is. But the guardian ad litems have a lot more contact with folks. And so it becomes more of a connection and becomes more personal. And so if a guardian ad litem doesn't follow the recommendation or doesn't give a recommendation that they believe is favorable to them, it's much easier to take that personally, to take that as some sort of offense to them. And so being a guardian ad litem is tough. That is not a situation that I wish anyone was in, as far as having to be in court, as a party, dealing with issues like that, to be fighting over your children or to be dealing with those issues. That is difficult in the best of circumstances. That's hard for people. But to be thrust in the middle and told you have to choose or you have to make a decision one side or the other, it's almost impossible situation. And there's going to be people that'll be upset, and there's just nothing they can do about it. And I am thankful for all the guardian ad litems that we have utilized in our courts over the years, and those that I've had experience with. Everybody's different. Everybody's skill set is different. Some guardian ad litems are better than others. But I can promise you that every single guardian ad litem that I have ever worked with has done their job with a focus towards doing what is right for their client.
That's got to be so tough. Okay. So this is really about helping people be prepared when they come to court. If you could tell people in Missouri some things that you found that surprises folks when they come to court, that if they knew ahead of time might just help them be a little more prepared, what would some of those things be?
I think that one of the things most often that I would see as a trial judge, as an appellate judge, I don't see it as much anymore because We don't have hearings. We have oral arguments, and that's the only thing we do. So I don't have daily interaction with people in court like I did as a trial judge. But in the 10 years as a trial judge that I did that job, I think one of the things that folks that would come in who are representing themselves, what I found would always confuse them is number one, they didn't understand the process at all. They had no concept of how the process worked, that they would have to stand in front of a judge, that they'd have to talk to a judge. They didn't think they'd have to do that. They didn't understand that they'd have to explain what it is that they want and why it is. They just didn't understand the process at all, which is understandable because not everybody gets involved in the legal system in their life. And so when that happens to you, it generally comes out of the blue. You're not expecting it. And so you don't know how to deal with it. If you don't have any familiarity with the system and how it works, what I would recommend to you is come to court. Don't come on the day your case is set. Come a couple of days before. Sit through a couple hours of court. See how it works. Watch other people handle their cases. Watch attorneys handle their cases. Get comfortable and see kind of the way cases get called and where people stand and how they address the court. All those things you can come in and observe for free anytime you want. Courts are always open, and I always encourage people to come and see us. But that can give you at least an understanding of how the process works so that when you come in, you're not so nervous. You don't have any idea how it works. You then know, oh, well, I need to stand here and they'll call me up and I'll go here. So you at least have some comfort and familiarity with the process. The other thing that I would encourage folks who are representing themselves, who are maybe the first time through the process, is do a little homework before you come. And I don't mean that necessarily on the process and, how the law works, but know what it is that you're asking for and know why it is that you're asking for it. And if you have evidence, if you have letters or photographs or emails or text messages, things like that, bring all of that with you. Have all of that information available and know what's in that information so that you can explain that to the judge or to the other side or to other people as to why it is, what it is you're asking for, and why it is you're asking for it. I saw so many people that would come into my court and they'd have a big file folder full of stuff. And I'd say, okay, what is it that you want? And they're, well, I'm not quite sure. I think I need this, but I'd really like this, or what? And I'd say, okay, well, what's in the file folder? And they say, well, this is all my documents. This is all my stuff. And I say, okay, well, what's in there? And they would say to me, I don't know. This is just all the stuff I had that's related to this. So know what's in there. Be able to explain to somebody why it is that you're coming in and asking the court for relief. Because if you can do that, if you can give the court an explanation for what it is that you're wanting, it makes it that much easier for the court to give that to you if they decide in your favor.
We may edit this out, or somebody else may edit this out,
Mhm.
but I will just tell you, when I was a foster parent, I've had to be in court to provide different things. I've just gotten a 3-ring binder, and you can get tabs at Staples. So just in case this is helpful to anyone, those 3-ring binders with the papers you can just pull out with the clear plastic things, and you can just stick as you come across documents that you think, oh, that'd be helpful. Print it, stick it in that tab that pertains to that question that might be asked of you. And that way, when someone asks, well, how did you come up with that number? Well, here's all the receipts and the total. Do you see what I'm saying?
Yeah.
And that way it's sort of all categorized. That was helpful for me. The other thing I think, and maybe you'll agree with this, but it really surprised me that when I was told, like as a foster parent, my time to come was 9 o'clock. It wasn't 9 o'clock. It was 9 to 1. Or if it was 1, it was like 1 to 5.
Right.
So if people can just, maybe understand that that's a docket time, they're either 9 o'clock, at least in my county,
Mhm.
or the counties that I served as a foster parent. It was either 9 o'clock or 1 o'clock. So you might just call and see what time frame is that really. And it's either usually, morning or afternoon, and plan to be there for 4 or 5 hours
Yep.
and have something quiet to do. Typically can't have any food or drink on the floor the courts are in, at least in my court area, and bring something quiet to do. So like no cell phones on speaker that can be heard by other people. And also understand that if you're in a situation where people that you may have a disagreement with are also going to be in that same space, It's just good to give yourself something to do that's calming to you, understanding that those people are going to be waiting for 4 hours in the same space as you, and just kind of keep yourself situated.
You've touched on a common complaint and a common refrain that we hear, which is, all the cases get set at one time. It's either at 9 or at 1, as you said. And every jurisdiction is a little bit different as to how they set the cases. I will tell you that with the onset of virtual hearings, that is changing some. Courts are starting to set more cases at, you set them at 10 and then 10:30 and 10:45. And then, so with the virtual hearings, scheduling those has become much easier. And so you will see some of that juggling of specific times for those virtual hearings because everybody has to know when to be on the WebEx. The problem is, and the why, there's a long tradition. I don't know how the history evolved of setting all the cases you have. If you've got 60 cases, you set them all at 9 and then you kind of get through them. But the reason is you don't know when everybody's going to be there for a particular case. You set it at 9, but everybody may not show up because attorneys that are involved in the case may have court in other jurisdictions, or they may be in other courtrooms in the building, and they may not all be able to be there right at 9 o'clock. And so it's going to take 3 or 4 hours to get through 60 cases anyway. So we set them all at 9, and then we generally take them up as they are ready to be taken up. I understand that causes a lot of frustration. And what I would tell you is that if you have something set on a date and that you have something that you really need to do, if for some reason there is some emergency. Now, it's not just because you want to get out of there earlier or you want to get home and watch, Young and the Restless. It has to be a reason. There has to be something important. If you've got that, then talk to your attorney if you have one. If you don't have an attorney, maybe make it known to the court on a break or some other time. Say, hey, Judge, I have this issue that I need to address this morning. Is there any way we could take this up? And then that sometimes we can move you up. We can get that done a little bit quicker. But otherwise, courts will generally take the cases as they're already, and we move them through as quickly as we can. But it often does lead to folks, maybe having to sit for a couple hours that they would otherwise prefer not to. So I wish we had a better solution than that. But with the volume of cases that are dealt with, particularly in the large cities where you have hundreds of cases on a docket, it isn't practical to set a case at 10 and at 10:01 and at 10:02. There frankly aren't enough minutes in the day to set all of the cases that may need to be covered. And it's just not practical to do that.
Right. And I just think it's good to just be prepared and just know that's what it is. And then there really isn't much stress around it because that's just what it is. One thing that I've been really interested in as I have done some research around the court is we have a lot of people in Missouri who go to law school or people who come here to go to law school. What are some of your best tips for surviving law school successfully and thriving and studying for the bar and passing it successfully?
I'll take the second piece of that first.
Sure.
Well, no, let's do it in numerical order. Let's get through law school and then let's talk about the bar.
Okay.
I don't know that there's any magic to surviving law school. Your law school experience is going to depend entirely on what you put into it, and I'm a big believer in that with any education. You get out of your education what you put into it. So if you want to get a good legal education and you want to go to law school and do that, if you put in the work and you put in the effort, you're going to be fine. As far as tips for surviving law school, first thing I think I would tell you is that it's going to be harder than you think. It always is, particularly the first year. It's a lot. It's designed to be a lot. It's designed to really test you and not just your potential legal ability and your knowledge, but how you handle pressure, how you manage your time, how you do all of those things that are inherent once you become a lawyer and become a judge. It's designed to test those things. So be prepared for it to be harder than you think it's going to be. Other tips I would give is make sure you make time to read. Your enjoyment of reading for class and for educational purposes may vary, but in law school, there is a lot of reading. You have to read a lot of cases. You have to read a lot of scholarly texts and information because the law is so varied and so thick and so dense. You can't cram it all into a 45-minute lecture. You just can't. You have to learn some stuff outside of those lectures, and that's going to be because you've read it. So you have to be prepared to make time to read when you're in law school. And finally, what I would tell you, tips for surviving law school, the third tip I would give you is don't forget to have fun. Law school is very stressful. It is very difficult, but it doesn't have to be your life. Make sure that you stay grounded in whatever you did for fun before you go to law school, keep doing it. Whatever you did to relax or wind down or just kind of center yourself when you're in law school, keep doing it. Don't become somebody completely different. Don't get so tied up in the law school experience that you forget those things that bring you joy and those things that bring you calm, because you are going to need them more than ever once you go through the process of law school and get wrapped up in that. So don't forget to have fun, to do those things that you like to do, even though you're as busy as all get out when you're in law school. Now, with respect to passing the bar, the bar has changed some since I took it many, many years ago. We won't discuss how many. The bar has changed some. And so the requirements have changed a little bit. What I would encourage anybody to do who is serious about passing the bar is take a good bar study course. There are lots of courses that are offered to help you study for the bar, some of them even online. If you don't want to leave your house, you can find a good online study process. Don't be afraid to take that class. You may not want to spend the money. You just spent 3 years in law school. You don't want to go sit in a classroom somewhere for another month and learn all about the law again and do that stuff. I highly encourage you, if you're serious about passing the bar, you need that additional help, because learning to take the bar exam is just as important as knowing the law that's going to be on the bar exam. They are two different things, and they're very important to learn them both. Other than that, I would suggest that you do take at least one practice exam or at least one section of practice exam so that you have some familiarity with how the questions will be constructed and what the mechanics are of the situation. Because when you step into the bar exam to take that exam, you're going to be in a big room with a bunch of other people and everybody's going to be stressed out. And you're going to want to have some familiarity with what it is that you're going to be asked to do while you're sitting in that room, because there's going to be a lot of distractions. So the more familiarity and comfort you have with what it is you're going to be expected to do once you sit down in that chair, the better off you're going to be. The third thing that I would recommend to you at the bar exam is figure out a way to block out distractions. Whatever it is that you do to center yourself or to put your blinders on and focus on, because during the bar exam, you're going to have distractions. There's going to be clocks ticking. And I'm not talking about distractions like they try to, they're not going to be like blowing off horns or shooting off fireworks or anything like that. But it's a very stressful environment. There will be somebody that has a panic attack. There will be, the chairs will be uncomfortable. The clocks will be ticking loudly. There will people that when you go off on a break and you go in the bathroom, there's going to be 20 people in there freaking out about, oh my gosh, did I get that question right? What did you put on that? How is that going on? There is going to be a lot of stress and freaking out that happens during the process of that exam. The best thing you can do is try to stay out of it as best you can, to focus yourself on what it is you're doing and what it is that you know, and just try to stay calm and just try to do the absolute best you can. So being prepared for those things, they'll help you. They're not a guarantee. The bar exam's tough. It is probably the toughest exam, the toughest professional thing I ever had to do in my life was study for and take that exam. So I was very happy when I passed it, that I would never have to do it again. But then I turned around and I ended up working at a firm in Kansas City, which practiced on both sides of the line. And so I had to go take the bar exam again in Kansas. So yeah, not on my bingo card was to take the bar exam twice in my life, but I've done it. And, I live to tell the tale.
Thank you so much for answering all of these questions. Inquiring minds want to know.
And I appreciate producer Michelle for vetting questions for us today and bringing these things to us. I hope that folks have learned a little something from this today. And certainly, if you have other inquiries, if you have things that you're curious about, want to talk about, don't be afraid to leave some comments on the podcast or on social media pages at Missouri Court's page or the Supreme Court of Missouri page. We love to interact with folks. We may not be able to answer your questions. If you have specific questions about your case and what happened in your case and why this went wrong, probably can't help you with that. But if you have general questions about the law and things that are going on, we'd love to interact with you about that. And maybe we can include them in a future episode. So once again, I want to thank producer Michelle for being here today. With nothing else to discuss, this podcast is adjourned.